You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Redhot. Possible your client waive the formal reading of the indictment.
She will, Your Honor.
Ms. Vargas, in cause number 26 DCCR 0081, the state has elected to proceed on count 1 only. It alleges that you committed the third-degree felony offense of harassment of a public servant from July 11th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And are you pleading guilty because you actually did what they charged you with?
Yes, Your Honor.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, I do.
Do you fully understand them?
I do.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Vargas is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the third-degree felony offense of harassment of a public servant. Sentence you in accordance with that agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. All right, good luck to you, ma'am. You can go back to the bailiff. Quentin Sells, that's a competency, right?
Yes.
Quentin Sells.
Quentin Bell. Now.
Let's see. Maybe, I'm not sure.
Yes.
Good morning. Are you Quentin Sells?
Yes.
And we've got cause numbers 25 DCCR 1473, 1474, and 1475. Mr. Sells is charged in each of those cases with assault on peace officer. I'm going to take judicial notice of the court's file in all 3 of those cases. Mr. Sells was previously found not competent to stand trial and was sent to the John Dunn Behavioral Science Center for competency restoration. I have received the report from them. In that, it includes a trial competency evaluation report dated May 4th of 2026. The opinion in that evaluation from a Dr. Emery is that Mr. Sells is currently not competent to stand trial, and that further treatment would be necessary for competency restoration. In addition to that, I also have the forensic psychiatry report, which is dated May 5th of 2026. Also, it is from a Dr. Shahani, also has that same opinion that Mr. Sells is still not competent to stand trial. Then I also have a physician certificate of medical examination for mental illness. This is from Dr. Shahani, dated May 5th of 2026. It makes the finding as well that Mr. Sells is not competent. It does state that he does not meet the criteria for inpatient, but would meet the criteria for an outpatient commitment for competency restoration, that the nature of his mental illness is severe and persistent, and that without treatment, he would continue to decompose and or deteriorate and not achieve competency. I also have a physician certificate of medical examination from a Dr. Polizzato. This is dated, well, let's see, uh, May 13th of 2026. It has the same finding that Mr. Sells is still not competent to stand trial, but that outpatient commitment is what he meets the criteria for, and that he would require further treatment for competency restoration. Is there any other evidence with regard to competency, Mr. Rojas?
No, Your Honor.
Mr. Coleman?
No, Judge.
So obviously, you both know, we all know that we do not have an outpatient competency restoration program here in Jefferson County. And so I will have no choice but to order further inpatient treatment at the appropriate facility. Hold on just a second. And so I am going to find at this time that Mr. Sells is still not competent to stand trial, that he is mentally ill, and that because of that, it is severe and persistent, and that if not treated, he would experience deterioration and the inability to function independently, and that treatment would be necessary. I'm going to order treatment at this point in an inpatient facility for a period of not to exceed 1 year under the civil commitment, and that we will await a report at that time. If something occurs before then where competency is restored, then they will let us know immediately.
Judge, I would like to say, I'm sorry to interrupt the court, but given the nature of these charges, the next time we are in court, if we are in a similar situation, the state will reconsider a way forward
Okay.
in these cases.
Okay, perfect. I know there's some civil locally, civil commitment that can be taken care of, but let's see if we can get maybe competency restoration between now and the next court date. If not, then we'll go forward that time. So you're going to go back to a hospital, follow all of their rules, okay, so that you can get better, take your medicine, and then we'll see if we can get your case taken care of.
I went to the health center and I went to all the conferences.
Right.
With the mentally conference with falls.
Right, I think the doctors still
This
think
one,
they think you need a little more treatment so that you understand all of your legal proceedings, okay? All right, you can go back with the bailiff. Mr. Rojas will visit with you. Thank you. Smith, I don't think there's any expectation of restoration. I think there's more of an issue of. So anyway, take a look at it.
Yes, Judge, I think there's another way we can go
Okay,
with this.
I agree.
Next time.
Johnny Segita or Segata?
I think it's a good.
Johnny. Johnny what?
Good morning. Are you Johnny Segata Jr.?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the indictment?
Here you go, y'all.
Mr. Segita, in cause number 26, DCCR 0795, you're charged with the second-degree felony offense of burglary of a habitation from April 21st of 2026. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and
Yes,
voluntarily?
ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rowe?
Yes, ma'am.
Do you fully understand that?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a cap of 10 years in prison, which means you're leaving your punishment up to me. And as long as I don't give you more than 10 years, I can give you 10, I can give you less. It'll depend on the information that's brought to me at a sentencing hearing. But as long as I stay within that range, you are giving up your right to appeal. Do you understand? I want to make sure you understand you have an absolute right to have a jury come in and determine 2 things. The first is if you're guilty or not. And then if they find you guilty, you could leave your punishment up to them.
Yes, ma'am.
If we go forward this way, you're waiving that. Is that what you want to do?
Yes, ma'am.
Do you also understand that if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? Also, it looks like as part of that agreement, the state is agreeing to dismiss cause number 26 DCCR 0796. Is that your understanding? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Segata is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing. And the probation department will do a pre-sentence report. That'll give me more information about your cases, and then we'll come back later for sentencing. Anything that you think is important for me to know, make sure you get that information to Mr. Rojas. He'll present it to me on your behalf when we come back. Okay, you can go back with the bailiff.
And that's where this hearing leaves you, Usnut, with a final sentence, but with one huge question. The judge now has a pre-sentence investigation to review, meaning the defendant's background, criminal history, and personal circumstances could all influence what happens next. Will the court show leniency, or will this burglary conviction lead to the full 10-year sentence? Share your prediction in the comments, and don't forget to follow for the sentencing update.